The United States of America is facing an emergency tonight. And no, it is not the emergency of the clock ticking to midnight without legislated funding for the American government. We've seen that clock tick to midnight before on nights like this, has created for the world. And that emergency is that the President of the United States, in his public appearance today, proved that he is mentally incapable and emotionally incapable of fulfilling his constitutional duties as President of the United States. There is no functioning intelligence, no functioning judgment mechanism within the mind of the current holder of the title, President of the United States. And that person is also the holder of the nuclear codes that could destroy the planet. A group of officers who earned their jobs in ways that Donald Trump never could, had to sit there and listen to a clown who stood before them in what appears to be a homemade brew of orange makeup. And I guess maybe we should accept Donald Trump's judgment about that one thing, that the madman orange makeup he slathers on himself makes him look better. Maybe it does.
Friends, thank you for being here today. We find ourselves at a pivotal moment in American legal and political history, a moment that demands not just our attention, but our careful, sober analysis. We are looking at a situation that transcends the typical partisan bickering and headlines of the 24-hour news cycle. We are witnessing a collision between the executive privilege often claimed by former presidents and the judicial branch's mandate for transparency. The subject at hand is the recent thunderous ruling by federal Judge Maryanne Keller regarding the unsealing of a massive cache of evidence related to Donald Trump. The title of this discussion frames the event as a humiliation for the former president, but to truly understand why, we must look past the emotional weight of that word and examine the strategic, legal, and historical collapse that this ruling represents. This was not merely a procedural loss, it was a systemic dismantling of a legal strategy that has defined Mr. Trump's public life for decades. Today, we are going to walk through this ruling step by step. We will examine exactly what happened in that courtroom, analyze the specific categories of evidence that have now been exposed to the light of day, and discuss why this particular defeat signals a fundamental shift in the legal landscape leading up to the 2026 midterms and beyond. Let us begin by stepping directly into the courtroom to witness this dismantling. To understand the gravity of the situation, we must first set the scene. In the American judicial system, rulings are often administrative affairs. A judge reviews motions in chambers, signs an order, and the clerks file it electronically. It is a quiet, bureaucratic process. That is not what happened here. Judge Maryanne Keller took a distinct and deliberate path. She ordered the unsealing of a large batch of Trump-related evidence, materials his legal team had fought aggressively, using every procedural tool available to keep hidden. But she did not simply sign the paper. Judge Keller chose to read the core of her ruling and its legal reasoning out loud, in open court, with cameras present. This decision to verbalize the ruling is significant. In the legal world, this is often done to ensure there is absolutely no ambiguity about the court's stance. By reading it into the record personally, Judge Keller removed the ability for political spin doctors to reinterpret her words or claim the order was a clerical error or a misunderstanding. She stated unequivocally that the public has a right to know what is in these documents. This phrase is the bedrock of the humiliation mentioned in our title. When a former president argues that his privacy or his executive privilege outweighs the public interest, and a federal judge publicly dismantles that argument point by point, it strips away the veneer of control. Judge Keller rejected every single argument presented by the defense. They claimed unsealing would interfere with ongoing investigations. She ruled it would not. They claimed it would unfairly prejudice Mr. Trump. She ruled that the public interest was paramount. They argued for valid reasons for secrecy. She found none sufficient to override the principle of transparency. The immediate unsealing order is particularly telling. Often, courts will grant a stay, allowing time for appeals, or order a gradual release of documents. Judge Keller's order for immediate unsealing indicates a judicial patience that has been exhausted. It suggests that the court viewed the arguments for secrecy not as valid legal concerns, but as delay tactics. By dragging these documents into the light immediately, the judge effectively declared that the time for hiding was over. I'm curious to know your thoughts on Judge Keller's specific approach here. Do you think reading the ruling aloud was necessary to ensure transparency, or do you see it differently? I invite you to share your perspective in the comments below. Now, having understood the judge's posture, let us move from the procedural drama to a forensic accounting of the unsealed files themselves. What exactly was Trump's team trying to hide? The unsealed cache is not a singular smoking gun. It is an arsenal of information. It spans transcripts of private meetings, detailed financial records, and internal communications. Each of these categories presents a unique and distinct threat to Mr. Trump's legal standing. The first area we need to scrutinize involves the transcripts of private meetings. Perhaps the most damaging aspect of these unsealed documents are these very transcripts. We must remember that public figures, particularly those at the highest level of office, live two lives, the one presented on the podium and the one lived behind closed doors. In public, rhetoric is carefully crafted. Sentences are polished to maintain plausibility and deniability. However, in private meetings, when participants believe they are shielded by confidentiality or privilege, guards come down. These transcripts reportedly reveal what Mr. Trump and his associates said when they thought no one else was listening. Why is this critical? Because in a court of law, intent is everything. It is often difficult to prove criminal intent based on public speeches, which can be protected by the First Amendment or interpreted as hyperbole. But if a private transcript shows a specific intent to circumvent the law, or an acknowledgement that an action was illegal but would be done anyway, that is evidentiary gold for prosecutors. These transcripts bridge the gap between political maneuvering and criminal conspiracy. This leads us to the second distinct category of evidence, the financial records. For decades, investigative journalists and prosecutors have operated on the maxim, follow the money. Financial records are uniquely dangerous to a defense because they are objective. You can argue about the interpretation of a phone call. You can debate the meaning of a speech. You cannot debate a bank transfer. A ledger entry is a fact. It has a date, an amount, a sender, and a receiver. The unsealed financial records allegedly show money flows that the defense wanted to keep buried. In the context of the various investigations surrounding Mr. Trump, these records likely pertain to how funds were raised, how they were moved, and ultimately how they were spent. If these records show funds being used to obscure activities, silence witnesses, or facilitate actions that were later deemed illegal, the numbers themselves become the witnesses. They are immune to cross-examination because they are mathematical realities. But perhaps the most explosive category lies in the internal communications regarding what are being described as potential illegal directives. This is where the legal peril is most acute. An illegal directive is exactly what it sounds like, an instruction from a superior to a subordinate to commit an act that violates the law. In corporate and governmental law, this cuts through the defense of, I didn't know. If the documents show a chain of command where specific instructions were given to violate statutes, whether related to election interference, the mishandling of classified documents, or financial impropriety, it creates a direct line of liability. Internal communications reveal the decision-making process. They show who proposed an idea, who pushed back against it, who warned that it might be illegal, and who ordered it to proceed regardless. The ruling indicates that these communications expose the difference between aggressive political strategy and criminal conduct. Mr. Trump's team fought to seal these because they likely dismantle the defense that he was simply acting on bad advice. If the emails show he was warned that an action was illegal and ordered it anyway, that is the definition of criminal intent. Of these three categories, private transcripts, financial records, or illegal directives, which one do you believe poses the greatest legal risk to the former president's legacy? I'd be interested to read your analysis in the comment section. Crucially, a significant portion of this unsealed material reportedly connects directly to the events of January 6th, specifically regarding security failures and the subsequent management of the fallout. For the generation that remembers Watergate, the phrase, "It's not the crime, it's the cover-up," rings with historical truth. The unsealed documents allegedly detail efforts to manage fallout from the security failures at the Capitol. This is a crucial distinction. We are not just talking about the riot itself, but the administrative and political response in the hours and days that followed. What did the president know about the security situation? When was he informed? And most importantly, what did his team do once the magnitude of the event became clear? If the documents reveal that the primary focus was not on securing the Capitol, but on constructing a false narrative to deflect blame or destroy evidence of inaction, that moves into the realm of obstruction of justice. Managing fallout can be a euphemism for a public relations strategy, or it can be a euphemism for a criminal conspiracy to impede an official proceeding. The unsealing of these documents suggests that investigators, and now the public, will be able to see the mechanics of that management. To truly appreciate the humiliation aspect of this ruling, we must step back and analyze the failure of the delay strategy that has defined Trump's legal life. For 50 years, dating back to his days working with the infamous attorney Roy Cohn, Mr. Trump has employed a consistent strategy: delay, deny, obstruct. The strategy is simple: never give up a document, assert every privilege, appeal every ruling, tie the courts up in knots until the clock runs out, the plaintiff runs out of money, or the political winds change. For decades, this strategy worked. It allowed him to settle civil cases without admitting guilt and to avoid transparency in his business dealings. However, Judge Keller's ruling represents a catastrophic failure of this strategy. The legal system, while slow, is not infinite. We are seeing a phenomenon where the courts are no longer accepting the delay tactic as a legitimate legal defense. By rejecting every single argument for secrecy, Judge Keller sent a message that the judiciary is wise to the game. The failure of this strategy is absolute. When you fight to hide everything and you lose, you don't just lose a little, you lose everything at once. The dam breaking effect means that instead of a trickle of bad news that can be managed over time, the defense is hit with a tsunami of evidence. All the effort, time, and legal fees spent trying to hide these documents were, in the end, wasted. This ruling exposes the limits of procedural obstruction. It shows that in the federal court system, facts eventually matter more than filings. Trump's inability to prevent this disclosure, despite his immense resources and influence, projects a weakness that is damaging to his brand of invincibility. As we look to the future, we must brace ourselves for a pipeline of revelations. The immediate unsealing of these documents does not mean the story is over. It means the analysis has just begun. We are entering a phase described as a pipeline of revelations. These documents are dense. They are complex. It will take time for forensic accountants, investigative journalists, and congressional staffers to process them fully. This creates a drip feed of damaging information that will persist for months. Each week, a new email chain will be deciphered. Each month, a new financial link will be established. This is a political nightmare. In a campaign or a legal battle, you want to deal with bad news in one news cycle and move on. You want to rip the Band-Aid off. Instead, this ruling ensures that the wound stays open. The unsealed materials will be analyzed and reanalyzed. They will generate new leads for investigators. As noted, every page could provide new leads. A single email mentioning a meeting can lead prosecutors to subpoena the attendees of that meeting. A single bank transfer can lead to a subpoena for the receiving account. To add a necessary layer of depth to this analysis, let us pause and consider the historical echo and the constitutional reality of this moment. Many of us here remember the summer of 1974. We remember the hearings, the tension, and ultimately, the Supreme Court ruling in United States versus Nixon. That unanimous decision established a principle that is resonating loudly in Judge Keller's courtroom today. That executive privilege is not absolute. In 1974, it was the Oval Office tapes. Today, it is these transcripts and internal communications. The medium has changed from magnetic tape to digital files, but the legal principle remains immovable. This parallel is vital for understanding the current gravity. Just as the release of the smoking gun tape eroded Nixon's support among the silent majority, the release of these transcripts poses a similar threat to Mr. Trump's standing with the exhausted majority of today. These are the voters who are not glued to cable news, who do not attend rallies, but who care deeply about the stability of the republic. For this demographic, hearing an audio recording or reading a verified transcript of a leader disregarding the law is fundamentally different from hearing a pundit criticize him. It breaks through the noise. It transforms a political debate into a question of character and fitness for office. I know many of you have lived through several administrations. For those who remember the Nixon resignation, does this moment feel comparable to you, or is the political climate today too different? Your historical insight is valuable to this community, so please share your memories below. Furthermore, we must address the constitutional argument that has been quietly dismantled here. For years, legal theorists in Trump's orbit have pushed a version of the Unitary Executive theory, suggesting that the president possesses an almost monarchical authority over the executive branch that cannot be checked by Congress or the courts. Judge Keller's ruling is a direct refutation of this expansive interpretation. By asserting that transparency and the public interest override the president's desire for secrecy, the court is reestablishing the boundaries of the Constitution. It is a reminder that the presidency is an office of service, not a position of ownership. The documents do not belong to the man, they belong to the people. This brings us to the internal dynamics of the political landscape, particularly the donor class and the traditional conservative establishment. While the headlines often focus on the vocal base, elections are fueled by resources and won by broad coalitions. The unsealing of financial records and evidence of illegal directives sends a chill through the donor class. Major corporate donors and establishment figures desire predictability. They fear instability. Evidence of criminal conspiracy is the ultimate form of instability. As these documents are parsed, we are likely to see a widening fissure within the Republican Party itself, between those who are personally loyal to Mr. Trump and those who see these revelations as an anchor dragging down the party's future prospects. The humiliation Judge Keller inflicted is not just personal, it is institutional. It forces every candidate running in the 2026 midterms to answer a question they desperately want to avoid. Do you support the conduct revealed in these documents? This transforms the midterms from a referendum on the current administration into a referendum on the rule of law itself. While we are analyzing this primarily as a legal event, we cannot ignore the political implications for the 2026 midterms. The political ramifications are undeniable. We are looking toward the 2026 midterms, a critical juncture for the country. The baby boomer generation specifically values competence and stability. We have seen enough political cycles to know the difference between a smear campaign and documented evidence. The release of these documents shifts the ground from he said, she said to here is the document. For political opponents, this is ammunition. It is difficult to campaign against a feeling or a movement. It is much easier to campaign against a specific transcript where a leader ignores the law. The unsealed documents provide concrete, verifiable instances of conduct that can be put into television ads and debated on stage. Furthermore, this erodes the narrative of the witch hunt. It is easy to claim you are being persecuted when the evidence is hidden. You can claim the evidence is exculpatory and that the deep state is hiding it. But when the evidence is public and it is damning, that narrative collapses. Judge Keller's ruling frames this as a victory for accountability, not persecution. By stating, the public has a right to know, she aligns the release with democratic values, making it harder for Trump to claim he is a victim of a corrupt system. The system, in this case, is working exactly as designed, to provide truth to the people. Finally, friends, we must reflect on the broader message that no one is above the law. Why does this matter to us as citizens? It matters because it reinforces the fragility and the resilience of our institutions. We often worry about the state of our democracy. We worry about partisanship. But moments like this should give us a degree of reassurance in the strength of the judiciary. Judge Keller did not act as a politician. She acted as a jurist. She weighed the arguments. She applied the law. And she determined that the title of president does not grant a lifetime of immunity from scrutiny. The humiliation of Donald Trump in this context is the humiliation of a man who believed he could outmaneuver the institutions of justice, only to find that those institutions are more durable than he anticipated. The courts are sending a unified message: you cannot use legal procedures as a permanent hiding mechanism. The United States of America relies on a system of checks and balances. For a long time, it felt as though the executive branch had grown too powerful, too secretive. This ruling is the judicial branch pulling back on the reins. It is a correction. So, as we bring this analysis to a close, where does this leave us? As we digest this news, let us remain vigilant and analytical. The headlines will scream and the pundits will shout. But the truth is found in the pages of these unsealed documents. The ruling by Judge Keller is a landmark decision. It strips away the secrecy that was the lifeblood of Trump's legal defense. It exposes the private reality behind the public persona. It provides a roadmap for investigators that will likely be followed for years to come. Trump wanted this buried. The judge dragged it into the light. And now it is up to us, the public, the voters, the citizens, to look at what has been revealed with clear eyes. We are not just watching a legal defeat, we are watching history correct itself. The secrecy has failed. The documents are public, and the damage, both legal and political, is ongoing. I read your comments to gain a better understanding of how this news is landing across the country. So please leave your thoughts below. What is your biggest takeaway from this ruling? If you found this analysis helpful, consider sharing it with a friend who values a deeper look at the news. Thank you for your time and your thoughtfulness in considering these weighty matters. We will continue to monitor this situation as the contents of these documents are fully analyzed. Until then, stay informed and take care.